Welcome to the Law in Context podcast.
I'm Emeritus Professor Stephen Bottomley, former Dean of Law at the Australian National University in Canberra.
And I'm Emeritus Professor Stephen Parker, former Dean of Law at Monash University in Melbourne.
Between us, we have written books and articles on corporations law, lawyers' ethics, family law and many other legal topics.
In most episodes, we take a legal topic of interest, perhaps one that's in the news, and relate it back to fundamental questions about the legal system.
So whether you are a member of the public wanting to know more about law and make sense of what is in the news, or you are studying legal studies, criminology, or even a law degree, our plan is to help you with a deeper understanding of what is going on.
In the last episode, we looked at 3 different meanings of the common law. One of those meanings was to distinguish between cases concerning common law rules and cases concerning equitable remedies.
In this counterpart episode, we explain what equity is, and in doing so, we look at competing approaches about how we should treat other people in our everyday lives.
So, dear listener, how do you feel about rules? Most people think they're a good idea in society, provided they're reasonable in the first place.
Suppose, however, you have a reasonable rule which is being used unfairly.
Suppose someone led you to believe that they would not enforce a rule against you, but then changed their mind after you'd relied on their assurance.
Suppose you agreed to buy some land because of its special features, but the seller then defaulted. The rules say you can get compensation in money for your loss, but you actually want that land.
Suppose someone is defaming you. You want them to stop now. You don't want to have to sue them and receive damages later.
Suppose you agreed to something in a contract, but the other party had much greater knowledge, you are vulnerable, and you think they took unfair advantage of you.
Welcome to equity, an area of law which has grown up when someone is behaving unconscionably in enforcing their rights, or when the rules are not in themselves enough to do fairness. In the first example, of someone leading you to believe they would not enforce their rights and then changing their mind, there might be an equitable remedy called estoppel.
In the second, where the seller of land defaults, you could seek an equitable remedy of specific performance to enforce the transfer of that actual land.
In the third, where someone is defaming you, the remedy of an injunction may be available, an order requiring them to stop.
In the fourth, where someone took unfair advantage of your vulnerability, you might have a remedy which these days is called unconscionable conduct.
This, if you like, is the ethical context of equity, that sometimes rules and rights are not enough or are used unfairly.
To bring it all to life, let's look at a recent case in the High Court of Australia. It involves a Mr Stubbings. In the words of the initial judge in the case, Mr Stubbings was completely lost, totally unsophisticated, incompetent and vulnerable. He could not calculate 10% of a simple number. He had no income, but plenty of debts. His financial situation was, in the words of the judge, bleak.
Simplifying the facts a little, Mr Stubbings found his way to a lender, aptly called Jams Pty Ltd. They engaged in asset-based lending, which is lending only on the strength of the security offered and without consideration of whether the borrower had the means to repay the loan. Their interest rates were well above normal bank lending rates, and in fact, Mr Stubbings had been refused a mortgage by a major bank.
When all the loan documents had been prepared, Mr Stubbings was required to go to a lawyer and to an accountant separately. The lawyer had to certify that the documents had been fully explained to him. The accountant had to certify that Mr Stubbings knew about the financial risk he was taking, and that to the best of the accountant's knowledge, Mr Stubbings understood it.
Of course, it all went wrong. Within a short time, he couldn't pay the instalments, and Jams Pty Ltd took proceedings against him.
Mr Stubbings won in the trial court, where the judge held that Jams Pty Ltd, through their own lawyer and broker, had behaved unconscionably. He lost in the Victorian Court of Appeal, which placed emphasis on the supposedly independent advice he had received. But Mr Stubbings won in the High Court of Australia in 2022. Crucial findings were that Mr Stubbings was at a special disadvantage, that is, over and above a common imbalance of bargaining power. Jams Pty Ltd must have known it could only end in one way, with them enforcing the security for the loan, and they were presumed to have known that Mr Stubbings had not understood this. You're listening to the Law in Context podcast by the two Steves.
Remember to rate us on the platform you are using.
Now, back to one of us.
Now, let's think about the case. The common law frame of mind would put weight on the fact that he signed a document, and if people aren't held to things they sign for, no transaction is safe. Furthermore, Mr Stubbings had legal and financial advice, which was apparently independent, although I have my doubts. He took a risk and it didn't pay off. The High Court quoted an historic English judge who said that a court of common law works its way to short issues and confines its views to them. In our case, these short issues might be the signature and the advice. A court of equity, said that English judge, takes a more comprehensive view and looks to every connected circumstance that ought to influence its determination upon the real justice of the case.
Mr Stubbings, after a 7-year battle, benefited from the development of thinking that goes back about 8 centuries to the Court of Chancery in England, initially presided over by the Lord Chancellor. Over the following centuries, Lord Chancellors often were religious clerics or had theological training. They infused their secular court work with these influences of conscience and morality. In particular, the Court of Chancery could be appealed to when the courts of common law would allow something that was not in good conscience, and at times there was outright competition between the two kinds of courts. Eventually, in 1873, the common law and equitable doctrines were fused in England, in the sense that all courts could apply both. But conceptually, as ideas, they continue to develop separately, and every so often a case involving an equitable principle provides quite a shock to the common law.
This is the case throughout the common law world now, although equity as a separate strand is more vigorous in some countries than others, and in India it has been codified into statute. It's tempting to see common law and equity as reflecting different political philosophies and ethics. Some place emphasis on individual autonomy, on looking after yourself, and on a society where the weak sometimes go to the wall in order to create an economy that is overall to everyone's benefit. Others argue that no amount of rules can do justice in every circumstance, and that we need a separate voice that can intervene to protect the vulnerable and state publicly a few core moral principles.
In some common law systems, such as Australia, England and Canada, equity has been in the ascendancy in recent decades. At the same time, the tort of negligence has expanded, which is broadly about taking reasonable care not to cause harm to those you can anticipate will be affected directly by your actions. We have also seen expansion of offences of dishonesty in the criminal law. Some listeners may approve of these trends, others may not. But if we end up with a legal system that revolves around just 3 principles of fairness, reasonableness and honesty, we might find that the law is not a good guide to conduct, that it is hard to predict in particular situations. Maybe we need some clarity in life, some tramlines as well as guidelines.
This is the debate that the law, in its context, grapples with every day. It's not a new debate. In the 17th century, an English jurist, John Selden, complained that one Lord Chancellor might have a different conscience from another Lord Chancellor. To quote him, one has a long foot, another a short foot, a third an indifferent foot. 'Tis the same in a Chancellor's conscience. At some point in a law degree, students will hear a strange reference to the length of the Chancellor's foot.
Personally, I think it's time to give that one the boot.
Thank you for listening to this episode. You can find more episodes in this gripping series at lawincontext.com.au or wherever you get your podcasts.
Over time, we will build up resources on the website with further exciting reading on the topics we've discussed.
We're the two Steves, and that was a Law in Context podcast.
As the two Ronnies used to say,
it's goodbye from me.
And it's goodbye from him.
Bye. OK, Steve, who said, "Let your conscience be your guide"?
Lord Chancellor.
Nope.
Aristotle.
Nope, it was Jiminy Cricket in the 1940 Disney film Pinocchio.
The long nose of the law.